We return this week briefly to the question of slavery in the Constitution. This was, of course, the subject that you were researching, and so I imagine you probably know more about it at this point than I will convey here. Therefore, I will leave this very short. We'll highlight the major constitutional issues in the 1840s and the 1850s, and think about how historically they play into the final drama of the Founders' Constitution. If we recall this chart here, and I'll put up the D2L link so you can look at these again if you like, but the federal power over slavery, of course, was fairly limited. It was contested in terms of what it meant precisely for interstate travel, the interstate slave trade, and of course for fugitive slave reclamation. And that in the 1840s began playing out, not so much in the matter of interstate travel or the interstate slave trade, because these remained fringe topics, but of course with fugitive slaves, as we will see. So too, and perhaps more so than anything else, was the subject of the United States territories. We will see this play out, of course, in the Kansas-Nebraska Act, as well as in the Compromise of 1850. Very interestingly, just so we know as a backdrop, the international slave trade will emerge again, not as a matter of constitutional controversy, in the sense that Congress has or has not the power to ban the international slave trade, but rather it will emerge as another issue in the radical South during this time. Now, if we go to this period of time between 1842 and 1860, that is between the decision in Prigby, Pennsylvania, and the Act of Secession by the state of South Carolina, we see an ever-escalating concern over the subject of slavery. It was a complicated constitutional story, so we'll try to make it as uncomplicated as possible here. The state of Texas was an independent republic for a number of years after its victory over the Mexican army in 1837. And slavery, of course, had traveled to Texas, and so Texas perpetually threatens to join the Union, if you will, as a slave state. And when I say threatens, I mean that there was a good measure of independence in Texas during that time, but there was also a clear desire to be part of the United States, to be part of its market, to have access to the Port of New Orleans, to have the trading status that is necessary, and the security, of course, that came with joining the United States. And slaveholders obviously want Texas in the Union, but abolitionists put their foot down. And this leads to a huge constitutional fight. And when I say constitutional, I mean that. Northerners refused to admit Texas on several occasions. It would take a lame duck Congress and a lame duck president to get Texas finally admitted. And meanwhile, abolitionists start talking about whether northern states have a right to secede over the admission of slave states, whether this violates the dictates of the Constitution as they understand it. This talk was not very serious, but it is debated in the North. And for their part, Southerners oftentimes say that failure to admit Texas is also grounds for secession. So talk is open of disunion during this time. There's no question about it. John Quincy Adams actually will make history by introducing a petition in 1842 from abolitionists asking for disunion. And the reading of this petition on the floor of Congress will lead to his censure. And it occurs actually only a week or two before the reading of the decision in Prigby, Pennsylvania. Now, in the 1840s, another issue arises, and that was David Wilmot's proviso, which he begins attacking onto various bills that are coming through Congress. And the Wilmot Proviso provided that there would be no slavery in any territory of the United States. So it was an attempt to use congressional power to ban slavery. And actually, it's not really that. It's, of course, a legislative trick. By putting this rider on virtually every bill that comes through, he threatened to stall the business of Congress. So it's a parliamentary tactic, which is being used at this point to indicate just how fragile the Union really is. And in 1848, 1849, the Wilmot Proviso becomes a major issue. And it's at this point that southern states begin talking about holding a kind of interstate convention, which they schedule for Memphis, Tennessee in 1850. And it was in the throes of this that the crisis is finally solved with the Compromise of 1850. And although I didn't go into all of the legislative and parliamentary drama that accompanies the Compromise of 1850, it's important to understand that the Compromise of 1850 really does avert what would be an early secession movement. And it consists roughly of three parts. First of all, it admits the New Mexico Territory on the basis of popular sovereignty, admits the state of California as a free soil state, and bans the slave trade in the District of Columbia, not slavery, but the slave trade in the District of Columbia, and passes a new Fugitive Slave Act. This is the Fugitive Slave Act of 1850. And I imagine by now everybody has had an opportunity to review the Fugitive Slave Act of 1850, so you know that it creates an entirely new regime for fugitive slave reclamation, one that was an ex officio summary hearing held by a judicial officer, either a district court or circuit court judge, or a commissioner appointed by the courts. And in this hearing, of course, being an ex officio hearing, the fugitive slave had no voice. There was a specific prohibition on the molestation of this process by any state process. In other words, state process is specifically disallowed. This has implications, of course, for the state's ability to free fugitives using a writ of habeas corpus. And finally, it allowed federal marshals the power of posse comitatus. This is the power to call upon all bystanders to help enforce the Fugitive Slave Act in the event of a rescue. And actually, something that is not often noted about the Fugitive Slave Act, it makes marshals directly liable for the enforcement of this law. So if a marshal has a rescue performed under him, it will actually directly make that marshal liable to the slaveholder. So federal officers are given an additional liability by this law. The Fugitive Slave Act of 1850, when it is passed, is an immense outrage in the North. And the result is some very prominent rescues that occur in 1851. The most prominent was that of Shadrach Minkins out of Boston. Shadrach was captured by a slave catcher. He was taken to the commissioner's court, and the commissioner was about to hear the case when the free black audience who was in attendance raised up, took Shadrach Minkins from the courtroom and ferreted him out of the city. So this was actually it was a dramatic rescue. It completely embarrassed Boston's court system, and they were quite aware following the rescue of Shadrach Minkins that it would be enormously difficult to take a fugitive out of the state. And in fact, the next fugitive picked up, Thomas Sims, would be very carefully guarded. And this is something that I actually wish I had images for because it's a very dramatic moment. In 1851, when Thomas Sims is captured, over 100 law enforcement officers, federal officers, deputized local officers, hold Shadrach Sims in the federal courthouse. At that point, abolitionists secured a writ of habeas corpus from the Massachusetts Supreme Court, and there's a brief moment where they don't know what they're going to do. Will the federal officers respect the writ of habeas corpus? Will they refuse to honor it? By the dictates of the Fugitive Slave Act of 1850, they are not bound to honor a state writ of habeas corpus, but if one follows state sovereignty to its natural limits, you would at least have to allow the judge, the state judge, to say that he is disqualified from acting, which one would presume he would do if he reads the Supremacy Clause, reads the Fugitive Slave Act of 1850, and applies the ruling in Prigby, Pennsylvania. And this finally is agreed upon. Thomas Sims is taken to the Massachusetts Supreme Court. The case is heard. The abolitionist attorneys make their arguments. The lawyers for the slaveholder make their arguments. And then Lemuel Shaw, the great justice of the Chief Justice of the Massachusetts Supreme Court, issues his landmark ruling where he denies the ability of a state court to issue a writ of habeas corpus in the face of this in the face of this ruling of Prigby, Pennsylvania, and passage of the Fugitive Slave Act of 1850. This would become the leading law, the leading case law on the ability of a writ of habeas corpus to interfere with a writ or with a slaveholder proceeding for the rendition of a fugitive slave. In order to guard against rescue, the federal government has to deploy the Army and the Navy to remove Thomas Sims and from Boston. And this runs at a cost of probably about $20,000. This is a fairly credible estimate of the expenses that the federal government must outlay to return one fugitive slave from Boston. And as you can probably tell, given that Sims's value was likely only $1,500, it's enormously expensive to remove fugitives from Boston. And this combined with a violent rescue that leads to murder in the state of Pennsylvania and another violent rescue that occurs in Syracuse, New York, means that the Fugitive Slave Act is very difficult to enforce. I'll come back to this in a little bit, but I want you to know that right now, looking at 1850, 1851, resistance to the Fugitive Slave Act is incredibly high. Now, things would then calm down. 1852 and 1853 saw a quieting of the slave issue. It appeared that the work of the Compromise of 1850 had done its job. And things would remain quiet until January of 1854, and then Stephen Douglas emerges. Stephen Douglas, at that point, reports a bill out of his Committee of the Territories in the Senate, and the bill would organize the Kansas and Nebraska Territory. And here you see a map of the Compromise of 1850 and the Kansas-Nebraska Act of 1854, what it would have done. And essentially, the Kansas and Nebraska Territory were unorganized territories which were not open to slavery by the dictates of the Missouri Compromise. Being unorganized territory, nobody had ventured there, or those who had done so essentially outside the protection of United States law. So it was an area that was supposed to be free soil, but that nobody could organize because it would potentially add more free soil states. And given the sensitive nature of political power in the Republic at this point, nobody was willing to organize that territory. The real problem here for Stephen Douglas, who is an Illinois senator, and more so than just being an Illinois senator, he's also a man with tremendous holdings in Chicago, huge investments in the city of Chicago, which is burgeoning during this time. And he desperately wants the new Western Railroad. They're talking about the first transcontinental railroad during this time. He wants it to run through Chicago. In order to make that possible, it's going to have to go through that unorganized territory. And so organizing the Kansas and Nebraska territory are absolutely critical to him. There are other promoters who would very much like the railroad to run either through St. Louis or even better through New Orleans. And New Orleans is actually the best option in a way because the New Mexico Territory is organized. In 1853, the Gadsden Purchase secures what is today the southwestern portion of Arizona, which is also the most friendly area to run a railroad through. So New Orleans actually threatens to get all of the business that would come from California trade should they not be able to build one through Chicago. So he organizes in 1854, he proposes the organization of the Kansas and Nebraska territories on the principle of popular sovereignty. The principle of popular sovereignty. And that meant that those who went there would be able to decide whether slavery would be appropriate in those territories. And so in the opening of this, of course, opens up an area reserved for free soil to the possibility of slavery. And there are dramatic consequences for this. Immediately, societies form all across the free soil states, Illinois, Wisconsin, Michigan, Indiana, Ohio. They call themselves Nebraska societies or sometimes Kansas-Nebraska societies. And they are dedicated to defeating this bill. These are political clubs. And these political clubs will actually come together. They begin corresponding with each other, and they begin creating state parties. And this is actually the birth of the Republican Party. The Republican Party is formed in 1854 out of concern over this Kansas-Nebraska bill. And they have immediate success in the 1854 election. it would be by 1856 a viable national party, and as we all know, in 1860 they capture the presidency. It would end the Whig Party. All the Whigs end up dispersing into either the Republican or into the Democratic Party. So the Kansas-Nebraska Act of 1854 is a fairly dramatic defeat of the old Missouri Compromise principles. It's also a decisive act politically. It changes the tenor of the nation, and it reinvigorates opposition to the Fugitive Slave Act. A rash of new rescues occur. The Fugitive Slave Act after 1854 is very difficult to enforce, and states begin standing on their sovereignty. Wisconsin, Ohio, to some degree Indiana and Illinois, although there it was much more difficult to muster the political will. But these states began refusing not just to help enforce the Fugitive Slave Act, which they're not required to do, of course, but also passing new personal liberty laws. And other northern states also pass, particularly New England, pass personal liberty laws that directly oppose the Fugitive Slave Act of 1850. It was during this time that everybody wanted some kind of solution to the slave question, and it is obvious that it will not come in Congress. Congress is simply too polarized at this point to prevent some kind of, or to present a credible solution. And so in 1857, it's then quite curious that James Buchanan, the incoming president, during his State of the Union address, suggests that the Supreme Court could handle this contentious question over slavery, and recommends that everybody very carefully follow this case of Dred Scott v. Sandford, which the Supreme Court was about to announce its decision in, and then says we'll all be very curious to hear what they say, and we will follow what they say. Now, the case of Dred Scott v. Sandford, one of the most complicated cases in Supreme Court history, and so rather than go through all of its complications, which would take literally another 20 or 30 minutes, I just want to barely lay out what happened there. Dred Scott was a slave who was taken to free territory. He was also taken to a free state, but for the purposes of this, it's important to know that he's taken to free territory. He sued in the Missouri courts for his freedom. He won his freedom. The Missouri Supreme Court overturned this. This is, I believe, in 1850 or 1851, something like that. And so Dred Scott remains a slave. And he then sued in a federal court in what was really a collusive case. But he sued in a federal court under diversity jurisdiction. And at this point, because of changes because of the death of his prior owner, his owner actually lived in New York. So what he does is he claims that he's a citizen of Missouri, and that his owner is a citizen of New York, and therefore under that diversity jurisdiction, he being the citizen of one state, his owner the citizen of another, they are able to go to federal court. He sues in federal court. There's a plea and abatement, which is a technical term, meaning that the slaveholder says, well, you can't sue me because you're not a citizen of Missouri. And that then is appealed up to the Supreme Court of the United States. The Supreme Court of the United States then sharply divides on a number of issues about what exactly Dred Scott is doing. As you can tell, all these legal issues can be divined here. Was Dred Scott free? Was Dred Scott a citizen? If he was he free because he went to federal territory? Once he's free, is he always free? It engages the principles of Somerset. It engages the principles of interstate comity. It engages the principles of privileges and immunities, where and how slavery is going to be recognized. So rather than go through all of these issues in detail, I'm simply going to go to what the judges end up deciding in Dred Scott. The case is notorious because Roger Brooke Taney issues this long ruling in which he makes a number of very dramatic claims, but not all of them are supported by the court. So it's important to specify here what is supported and what is not supported by the court. So, and as a result, his opinion of the court is only, in a way, sort of partially accepted by the remainder of the justices. First of all, there was broad agreement on the court. 7 of the 9 justices ruled that Missouri laws determined Dred Scott's status after his return to that state from Illinois. So even if he went to Illinois and was free by Illinois law, even if he was free potentially by federal law, by visiting free territory. When he returns to Missouri, Missouri law holds. This follows Strader v. Graham, a case I had not gone over, but is a very simple case that decided the same point. So it's not a controversial holding of the court that Missouri law, local law, would determine Dred Scott's status. This connects, of course, status connects to the police. And so if the police power is firmly with the states, this is really an uncontroversial ruling in antebellum America. Second, they held that Dred Scott is still a slave. And here, once again, the same coalition of justices said very clearly, if Missouri law holds, then Missouri law has held that he's a slave. And there is simply no way around this ruling. Illinois law does not hold, and no federal law is relevant. But the next rulings of the court were very, very controversial. First, that the Missouri Compromise was invalid. And here 6 justices agreed to this. Now, what this meant, by the way, was that the Missouri Compromise, of course, had declared that above the line of 36 degree 30 minutes, slavery would not be allowed. And essentially what the court said was that this was in violation of the Fifth Amendment of the Constitution, and that being in violation of the Fifth Amendment of the Constitution, which guaranteed slaveholders the right to their life, liberty, and property, guarantees to everybody their life, liberty, or property, without it, unless taken away by due process of law, means that Congress cannot ban slavery in the territories, or if they do, that they must either provide some means of compensation or provide for some means of due process. And so nobody knows quite what this means, but they do know. They do know that the Supreme Court has now tried to solve what was the biggest constitutional question over congressional power in antebellum America. Do they have power to prevent slavery in the territories? 6 of the justices say that they do, rather that they do not, that the Missouri Compromise was invalid, and that Congress may not pass laws on this subject. The most controversial portion, and the one not accepted by a majority of the court, was Taney's holding that a descendant of slaves cannot be a citizen of the United States, and therefore had no right to sue in a federal court. In fact, could claim no rights whatsoever under the Constitution. So this final holding, which is notorious and makes Dred Scott still a notorious decision, was not held by a majority of the court. Dred Scott, which comes in 1857, the decisions held out in 1857, would turn out to be the kind of final straw. After this, there simply is no way to reconcile Northern and Southern views on slavery and the Constitution. And I've brought us back here to this timeline so you can think about this in conjunction with the Week 9 lecture on the history of slavery and constitutional issues. Precisely how, by 1857, politics and constitutionalism and law had essentially reached an impasse. And as we move closer and closer to the election of 1860, this inevitability of confrontation appears to be coming to a head. And partially it's because politically the Democratic Party was fracturing while the Republican Party was solidifying. And also because Southerners made it clear that there simply was no compromise to be had, and increasingly so were abolitionists.